Hello, my name is Anna Cook, and this is my tort liability presentation. What is tort liability? It is kind of an umbrella term for a lot of different situations, but it's a legal term that describes a violation where one person causes damage, injury, or harm to another person, typically resulting from intentional actions, but it's not always the case. An example, here are 5 examples. The first one is proximate cause. I reviewed Jackson versus Hankinson in 1967. There was a bus rider who was seeking damages. He had permanent eye visual loss from objects being thrown on the bus ride. The verdict ruled that there was neglect shown to the bus riders from the school bus operator. In my district, every student who rides a bus, they sign a contract where they abide by the code of conduct. Bus drivers do review this every day. The consequence for any acting up would be in accordance with the contract. And it's a contract that is not only approved by the bus company, but by the school district as well. In some situations, there are 2 adults riding the bus, one to monitor behavior and the other to safely drive the students. And a code of ethics, this would be a duty to protect the students. Their safety is at stake, not only from transporting them safely, but to monitor behavior as well, because in so many times the adult is focused on driving and not on anything else. Another one I reviewed was battery. This was Frame versus Como, 1999. Student was assisting a disruptive student to leave the classroom. Student was taking their time. Charges were filed against the teacher for using unnecessary force, assault, and battery. The case was determined that the that the teacher was within their rights to remove the student from the room, and that it was monitoring the safety of others and doing so in a timely fashion because the student was showing resistance. In my district, teachers are encouraged to touch students as an absolute last resort because of this. I've heard of this happening, but I've never actually read a case on it, so that was really interesting. They say only touch a disruptive student when fearing for the safety of other students. So if a student becomes physically a threat, then you are allowed to block, shield, and guide them out. But if they are being disruptive in a stationary position, verbally disruptive, not physical, of a threat, then you are not to touch them. We are trained with other tools to diffuse a situation. Regarding a code of ethics, this also struck me as a duty to protect. I would only even consider touching a student if I was trying to protect the other students. Is disruptive student affecting the majority of a classroom student in a negative way that could compromise their safety? Okay, the third example was neglect or negligence. I picked this example of a case because it's one that is really common in my situation. Rogers versus Christina School District. A student expressed self-harming thoughts and physical attempts to a school counselor. They had one-on-one for about 4 hours and then released the student back to class and notified school staff of situation and declared him no longer a threat. The school, faculty, administration, counselor never notified the student's family, and the student did commit suicide that same day once they got home. I actually have not received formal training on this. I've received my training through experience. I've had several students. I think being an elective teacher, students are, we talk about emotions every day, and I've gotten close to some students who have expressed attempts, self-harming. And so my interactions with the counselors, I always document. I document to counselors. I bring the students to the counselor, administration, Sometimes if I'm really close with the student and I kind of know the situation, I will reach out to parents after the school counselor does. But the school counselors always reach out to parents if there is a real threat of self-harm. Family is always notified in situations of students showing intentions to self-harm. That is a very strict Shawnee Mission policy, and I totally understand why. Code of ethics, this really is just what is the best for the student. We're thinking of their emotional and physical and social needs of the student and what can we do to best support them. Reasonable cause for search and seizure. New Jersey versus the TLO podcast in 1985. This was in one of the resources that Dr. Gooch had provided on the website, and I thought it was really interesting because it's also relatable in my demographic. Students were caught violating the smoking policy on school grounds. When they were brought to the principal, further search was conducted, and they found illegal possession and distribution of marijuana. The student had confessed, and with the confession and the possession, charges were brought upon the student. The court sided with the school, but there was a third party that did not, they felt like the Fourth Amendment right had been violated, and so they took that to court, and it did result in the support for the original verdict. In Shawnee Mission, when encountering drug possession or usage, we have a great team of SRO officers that are always called to the scene, and administrators handle it. If a teacher is involved, let's say I found something and alerted administration to it, I would type up like some kind of documentation of what I found, when I found it, etc., and then kind of make my statement and hand it off. But it is completely handled through administration and our SRO team. If need be, court cases are determined with the aid of the SRO officer policies and the district legal team, depending on the violation. Code of ethics. This one is a little bit more clear-cut, abiding by the law of possession and use of drugs by a minor on school grounds. Kind of ticks all the boxes there. So, lastly, I reviewed false imprisonment. This is something when I taught elementary school, I feel like I saw more now that I'm at the middle and high school. You don't see students needing to be restrained physically as much or isolated, but I did find this one interesting. A student was disruptive in a class period, and a teacher isolated a student in a small, dimly lit room for 3 class periods. The room was not locked from the outside, and the student was not held against their will. They showed no resistance to the teacher's direction of being isolated in the room. They could have left at any time. They could have challenged. Later, after the fact, they sued for emotional distress, false imprisonment, and negligence after the fact, and the case was almost immediately dismissed. In Shawnee Mission, any discipline issues that are handled by the administrative team and documentation of any student leaving the classroom is really pressed upon to be done as soon as it can. I actually haven't had a student do it, but I'll often receive kind of staff emails, hey, so-and-so just left the classroom, did not say where they were going. And that way it alerts staff and faculty to just immediately be on the lookout for this person. Because we are kind of told to not keep them anywhere. As far as administration goes, I once was in the office when they were talking with a student about a very serious issue, and he should not have left the situation. He was mad, he was upset, heated. You could hear a couple doors slam, but they did physically not restrain him. So false imprisonment is notify, correct people. The SRO team is really who handles that, but we are not to physically restrain nor confine individuals against their will. Code of ethics, this does result in the safety of students at all times. Was student isolated because of threat to other students or to punish misbehavior? Should the administration have been involved much earlier? that is the first thing that struck out to me was as soon as the bell rang, I would have dismissed the student to go to their other classes. Intentional infliction of emotional distress. This is one that is really recent, and there had been a previous lawsuit in a school district regarding a student, and the principal had resigned and his wife had resigned, and he was cleared of doing any wrongdoing in that case, and it had been, one of murmurs of child molestation. He was dismissed on all charges, but kind of with the understanding that he would be rehired back, and the school district did not rehire him or his wife, and he was suing for defamation and emotional distress regarding failure to rehire and for not making a public statement regarding him being cleared. In Shawnee Mission, we've had a few high public lawsuits recent years. The ACLU, I think, has an ongoing one regarding a walkout that we had last year. District lawyers handle any legal action taken by community members, staff, or students. If anything is initially handled at the building level, again, we make statements, and then district attorneys take it over. Basically, we're kind of led with, if you do anything, make sure you can stand behind it with a statement and understand you need to kind of stand behind your own judgment. And the district will, of course, advocate for what they think is best, but it might not always be you if you have violated some rights. Code of ethics, confidentiality, and professional integrity. Making a statement could have affected the minor involved in the previous case that was mentioned in the article. And how does the school district want to move forward after the previous lawsuit? So I think just that, taking the professional integrity of the situation to heart, and it's probably a decision that many, many people on the school board need to agree upon before. And here are my sources. Thank you.